exploring how we can master ourselves by looking at how authors and experts say it is possible, with your host, Shashiti Basu.
Welcome to Season 3, Episode 99 of How to Be, with me, Shashiti, as your timid presenter, guiding you through life's tricky topics and skills by reading through the best books out there. Although we like to believe that our courts are impartial arbiters of justice, courts, like other human institutions, are far from perfect. Even though the UK legal system dates back more than 900 years and is one of the most influential legal systems in the world, and in many cases is the basis for many Western judicial systems, there are still real-life issues that we see on a daily basis. So, what are the challenges of the legal system wherever you are? Our first book is from Her Honour Wendy Joseph KC, who until March 2022 was a judge at the Old Bailey, sitting on criminal cases, trying mainly allegations of murder and other homicide. She read English and Law at Cambridge, was called to the bar by Gray's Inn in 1975, became a QC in 1998, and sat as a full-time judge from 2007 to 2022. When she moved to the Old Bailey in 2012, she was the only woman amongst 16 judges, and only the third woman ever to hold a permanent position there. She was also a diversity and community relations judge, working to promote understanding between the judiciary and many different sectors of our community, particularly those from less privileged and minority groups. She mentors young people from a variety of backgrounds who hope for a career in law and has a special interest in helping women. Unlawful Killings is her first book. It was eye-opening speaking with her, hence here's a snippet of our chat, but find the full interview on www.howtobe247.com on the YouTube channel.
For a long time, as well as the day job in court, I'd been doing the diversity work outside court, and that involved lots of stuff like having groups of school children in to talk to them. When the pandemic came along and I was sent away for 4 or 5 months and told not to trouble them, they really weren't sitting, I couldn't do any of the in-court work, and that was just the fact of life. But it was really troubling me that I couldn't do any of the diversity work. So it occurred to me that I might just be able to write a little something, and I was really thinking of a pamphlet. The book begins with an introduction of a school visit after court hours, and that's what I wrote first of all, intending that it would be like a pamphlet that could be sent out to schools. I knew someone who was a literary agent who looked at it and said, as they do, could you write a bit more? Could you write about a case? So I did, and she said, could you write about another case? So I did, and the next thing I knew, I had half a book. But I really wrote it intending that it would be something very small and useful to those who would otherwise have been visiting me at the Old Bailey. Well, the first thing to say is, of course, each of the cases that I describe in the book, so, there's one about knife crime, one about gang crime, one about mental illness, one about domestic violence and sexual abuse. Each one of them isn't a specific case that happened. What I did was to identify an area I thought was important to people, and then I went back and looked at all the cases I'd done on that sort of subject, and then I drew interesting things from them and created the story, because I took the view it just wasn't fair or right to expose actual people's misery in a book. So each story is not real in the sense you couldn't go and find that case, but everything in each story is true in the sense I have seen every single one of those things happen somewhere. So, to answer your question about what it's like, it's difficult, but people think that judges are lawyers. They are lawyers, of course they are, and you have to know a bit of law. But most of all, you just have to know where to go and look up the law. The real job of a judge in a criminal court is really what you might call man management. The job is to make sure that everyone involved in the case is fairly dealt with and gets the fairest possible trial. And so what you're really doing is constantly monitoring the situation, because if you've got a witness who's a 34-year-old man with no problems, he can walk in, get into the witness box, give his evidence, not difficult. If you've got a battered wife giving evidence, or if you've got a 9-year-old child giving evidence, it's very different. And the way that a judge needs to react to that is very different to ensure that that witness has the same fair crack of the whip, the same fair chance to get an account across and have it accepted by the jury. So what you're really doing is dealing with people all the time. And it is difficult. No one said it was easy, but it's so interesting. I mean, it must be one of the most interesting jobs in the world and a huge privilege to be able to do it. I suppose people have always been greedy. There's always been crime related to people trying to get money in different ways. But people are greedy for slightly different things now. So they are greedy for fame and acknowledgement now. They are greedy for a position now. And the combination of people being greedy for a place to go, to be seen, to be recognized, and greedy for money is quite a dangerous one. And it's probably, I can't be sure, but it's probably one of the reasons that have led to so much gang crime. So that youngsters who aren't getting recognition in one more traditional aspect of their lives, maybe at home, maybe at school, get very tempted to join gangs where suddenly they've got respect, if you want that sort of respect, but many of them do. The carrying of knives is really the gaining of a position in the eyes of other people. So when you say greed, I think there's always been greed, but I think we need to be very mindful about what people are greedy for these days. Yeah, I mean, the simple fact is, whether it's mental ill health or whatever the problem is, by the time it gets to the Old Bailey, by the time it gets to any court, it's way too late to put it right. At the Old Bailey, the likelihood is, by the time a defendant gets through the door of the Old Bailey court, he or she they're going to be in the dock with the risk of serving very, very long sentences, and somewhere else there'll be a dead child on a mortuary slab. So it's way too late to put it right. No judge can put that right. They can make sure the trial's fair, but they can't undead someone. So you really do need, as you are saying, to go way back. And mental ill health, as with physical ill health, as with all the other problems which lead unhappy families, problems at school, all the things that lead young people through the doors of the court, they all need to be tackled. And they're all what you might call treasury driven. They're all about money. They're all these things, I'm not saying they could be mended, but they could all be made a lot better with money. It's just a question of how government ultimately spends limited resources. But just to say this, when I see kids of 5 and 6 and 7, they have a very strong sense of morality. And it's a very simple sense of morality. They don't like being hurt. They get that being hurt is wrong, and they get that hurting other people is wrong. Somewhere between being 5 and 15, something changes. So we really need to be in the schools. We really need to be there and talking to people. Because when you bring a school group into the courtroom and show them what's happened, they are responsible, sensible in the way they approach it. But out on the streets, they may not be. I think knowledge is a good thing. I think almost all knowledge is a good thing. And I would like children, as I would like everyone, to understand the system, which is really, why I wrote the book, because the courts are a service industry. That's what they are. They're there for society, for people. And it's amazing how people don't understand how the system works. And here's an example. We expect groups of 12 people who don't know each other, come from completely different backgrounds, with all sorts of different experiences and abilities, to sit down together and discuss things. Now, my experience is they are amazingly good at it, and that it's really moving to see how dedicated they are, certainly in serious cases, to getting it right. But most of them will never have had the experience of sitting around a table with 11 other people discussing an issue. And that may mean that there are some people who find it difficult to find their voice to express their view. It may mean there are some people who find it difficult to shut up and let other people do the talking. I don't understand why we don't teach children in schools to sit down in small groups and discuss issues, to learn to listen, to learn to express a view, to learn that there's nothing wrong with adjusting your view if it suddenly occurs to you that maybe you missed something. I don't know why we don't teach children that. When I first came to the bar, so I'm very old, and I came to the bar in 1975, there were comparatively few women. It's very different now. Over the years, there has been an increase in diversity, diverse backgrounds, diverse ethnicities, but nowhere near enough. We are seeing much more diversity amongst barristers and solicitors in the criminal courts, but we're not seeing enough. We're not seeing enough at the top end, and the result of that is we are not seeing even remotely enough on the bench. When I went to the Old Bailey, there were 16 full-time judges, and as you said, there were 15 men and me. But it wasn't just 15 men, it was 15 men over the age of 60, all white, all middle class or upper middle class, all with similar backgrounds. By the time I left the Old Bailey, almost exactly 10 years later, of the 14 full-time judges, 7 were women. So a huge difference, and a big difference in backgrounds and experiences. But on the ethnicity front, we have just not been making the progress we absolutely should have been.
As mentioned, Joseph talks about her experience presiding over a school visit to the Central Criminal Court known as the Old Bailey. The judge, who also works as a diversity and community relations judge, interacted with a group of Year 9 school children as part of their citizenship course. She then assigned roles to the students, including defendants, prosecutors and witnesses in a mock trial scenario. One student named Shane, all of the names are pseudonyms in this book, volunteered to be the witness and impressed everyone with his bravery. The mock trial concluded with the jury delivering a verdict and asking about the potential sentences. As a result, Joseph reflected on the importance of rules in the legal system and how they govern the decisions judges make every day. The book provides a summary of the key roles and individuals involved in a criminal court proceeding, specifically focusing on the Central Criminal Court in England and Wales. The cast of characters includes the defendant, who is the individual accused of committing a crime, who is central to the court proceedings. Cases often involve serious charges such as murder, manslaughter, or other violent offences, frequently related to gangs, drugs, or firearms. The solicitors are legal professionals who provide advice to clients, arrange for legal representation, and handle various legal matters including criminal defence and prosecution. They often collaborate with barristers in court cases. The barristers themselves are courtroom advocates who specialise in specific areas of the law and are called to the bar after rigorous training. They represent clients in court, including both prosecuting and defending cases, as well as, of course, the judge, who are experienced legal professionals who preside over court proceedings, making legal rulings and ensuring that trials are conducted fairly. Judges in the Crown Court are typically appointed after years of legal experience as barristers or solicitors. The witnesses are individuals who provide information or evidence related to the case. They can be eyewitnesses, professional witnesses like police officers, or expert witnesses who provide specialised knowledge or opinions in various scientific or technical fields, as well as the clerk and ushers, who are courtroom staff responsible for managing various aspects of the courtroom proceedings, including recording, administering oaths, and ensuring the courtroom functions smoothly. And finally, the jury, who are a group of 12 individuals selected randomly from the community to decide the verdict in a trial. Jurors must be impartial and are expected to evaluate the evidence presented during the trial before reaching a decision. Jury service is considered a civic duty. Joseph stressed the importance of the jury system in the English legal system, highlighting its role in achieving a verdict based on collective conscience and life experiences. In Trial 1, Daniel Devon, a 15-year-old working in a chicken shop in North London, enjoyed his job and life. During his break, he goes into an alley off the high street and encounters someone with a knife. Despite being warned never to run into a blind alley, he does so, and sadly he was killed. 3 boys, Shadrach, Meshach, and Abednego, were accused of the murder of Daniel. Joseph talks about the legal proceedings as the trial begins with a focus on the selection of the jury, opening statements, and the presentation of circumstantial evidence. The case relies heavily on circumstantial evidence, since there were no eyewitnesses to the stabbing. During the trial, Shadrach is called to the witness stand. He claimed that he can't drive and denied being involved in the incident, asserting that he lent his mother's car to Meshach, who drove it that day. Meshach follows, vehemently denying his involvement in the murder and maintaining that he didn't go into the alley where the stabbing occurred. However, Meshach's previous conviction for car theft is exposed, which further complicated his situation. The last defendant, Abednego, eventually decides to come clean and admits that he had not been truthful before. His willingness to tell the truth signals a significant shift in the case, and he prepares to provide a new account of the events. Abednego testifies about a past falling out between Daniel, Meshach, and himself. Meshach, angry at Daniel, enlisted Abednego to confront him in an alley. Abednego claims he didn't know Meshach had a knife. Meshach then denies being there, but Abednego insists he was. The barristers present their cases, emphasizing the jury's grave responsibility, and then Joseph explains the burden of proof and outlines the steps to reach a verdict. Meshach, as a result, is found guilty of murder, Abednego of manslaughter, and Shadrach is acquitted. The judge had to then determine their sentences, with mandatory life imprisonment for Meshach. The story highlights the complexities of youth involvement in knife crime and the need for prevention over deterrence, focusing on addressing the root causes rather than punitive measures. In Trial 2, Mrs. Manders climbed the stairs to check on her daughter Ruth, who is in the nursery with baby Zara. Mrs. Manders is relieved to see Ruth being tender with the baby, but soon realized that the pink rabbit is covering Zara's face and the baby's movements are weakening. In late September, the trial against Ruth was scheduled at the Old Bailey. While Joseph had hoped to be on vacation in the Pyrenees, the case revolves around the alleged attempted murder of Ruth's baby, with Ruth's mother as the key witness. However, when the mother refuses to testify against her daughter, legal complications arise. The prosecutor attempts to cross-examine her, and the judge considers the possible charge of attempted infanticide. Ultimately, the mother is persuaded to testify, but the trial's outcome remains uncertain, with complex emotions and legal dilemmas surrounding the case due to the mother-daughter dynamic. Ruth's trial takes a dramatic turn when text messages from her mobile phone reveal an abusive relationship with her music teacher, leading to a motive for her alleged attempted murder of her baby. The prosecution and defense have to now consider how to interpret these texts, whether they support an attempted murder charge or suggest a different intention. Ruth's mother was present, and the court had to grapple with the implications of this new evidence. As a result, the Crown thinks about dropping the attempted murder charge against Ruth, opting to add a lesser charge of child cruelty due to late evidence discovery. After Ruth pleads guilty to child cruelty, the jury is discharged and a retrial is ordered. The judge contemplates Ruth's sentence, considering her mental state and minimal harm caused to her child. Meanwhile, the music teacher who abused Ruth faced investigation. Joseph talks about the challenges of prosecuting child sexual abuse cases, emphasizing the need for victims to be heard, belief in their claims, and efficient police investigations to bring abusers to justice. In Trial 3, Jude finds himself in a wrecked car with his friend Lam. Lam is seriously injured with a pole from a bus stop having penetrated the car's windshield and skewered the back seat. Despite the gruesome scene, Lam manages to speak, claiming it was his fault. Jude realizes Lam is dead and contemplates their situation amid the chaos of screams and sirens outside. Joseph then accessed the case of Jude Derwent, who had been charged with causing death by dangerous driving. Jude accepted his guilt but disputed certain details of the case, prompting a potential Newton hearing to determine the facts. The hearing could have significantly impacted his sentencing. Meanwhile, the grieving father of the victim, Lambert Dixon, reacted emotionally to the situation, revealing that Lambert had a hidden side. The legal process became complex as the prosecution and defense presented their cases, and the judge grappled with the decision of whether to proceed with the hearing or accept Jude's plea based on the defense's version of events. The Crown alleged that the incident was a gang-motivated attack on the G-Men gang. However, Jude unexpectedly admitted to his dangerous driving and acknowledged his knowledge of Lambert Dixon's gang affiliation. This confession shocked the courtroom, especially Lambert Dixon's father, who vehemently denied his son's gang involvement. Jude tried to explain his actions, stating that he had attempted to communicate with Mr. Dixon, but he had been met with rejection. He believed that Mr. Dixon needed to understand the truth, even if it wasn't what he wanted to hear. The courtroom was left in a state of confusion, with Mr. Dixon struggling to accept the unexpected revelation. Joseph acknowledged the complexity of the case and the genuine remorse displayed by Jude during the trial. Ultimately, Jude received a 5-year sentence in a young offender institution. She then delved into the broader issue of gangs in society, exploring the factors that lead young people to join them, such as escaping troubled homes and seeking belonging and excitement. The author calls for a deeper understanding of these factors to address the gang problem effectively. She highlighted the importance of providing support and opportunities for at-risk youth to prevent them from being drawn into a life of crime. In Trial 4, The Offering, Shugra and her younger sibling Atta witnessed a heated argument in their home involving their parents and older sister Kubra. Kubra, at 16, rebels against her father's wishes and runs away. That night, Shugra hears another argument but hesitates to intervene. The next morning, she finds her family in the darkened front room with Kubra and her father reading the Quran together. Shugra is sent to school and tasked with taking Atta with her. At school, Atta becomes inconsolable and the police later arrive at their home. As a result, Joseph was called upon to preside over the case involving the death of Kubra. The circumstances surrounding Kubra's death are mysterious and the judge had to determine what happened. Kubra's younger siblings, Shugra and Atta, are potential witnesses, but Atta is too traumatized to speak during an interview. Shugra, however, provides a detailed account of the events leading to Kubra's death. According to Shugra's testimony, Kubra angered her father, referred to as Baba, by wearing different clothes and ran out of the house. When she returned later, her parents took her into the front room, where Baba hit her and put a scarf around her neck, strangling her to death. Shugra recalls seeing Kubra with friends from school before her return home, but cannot provide many details about what happened in the front room. 9-year-old Shugra had previously provided clear evidence of her father's abusive actions towards her sister Kubra. However, her mother's role in the situation was also being questioned. Barrister Bryson Haig conducted the cross-examination. For Joseph, she had to make sure that the ground rules were followed, including treating the child witness with care and sensitivity. Haig challenges her account, focusing on how she saw the events unfold. Sugra struggles to answer, and Mr. Haig's aggressive questioning upsets her. She eventually admits to lying because another child, Atta, had witnessed the incident, but she couldn't convey his account as per the rules. After a break, the prosecutor decides to re-interview Atta. However, unexpectedly, Mr. Ibrahim, Sugra's father, pleads guilty to the murder of Kubra. As part of a deal, the mother is released. The judge reflects on the complexities of domestic violence cases, the fragility of child witnesses, and the challenging role of the court in ensuring fairness. In another trial, Joseph talks about the death of husband Charlie, with wife Angela Bridges being accused of killing him using a firearm. The defendant is accused of deliberately shooting the victim, who was a violent criminal. We discover domestic abuse, Angela's history of injuries, and the defence's argument of loss of control. The prosecutor delivers a compelling opening statement alleging that Angela committed murder, not manslaughter as claimed by the defense. In the trial's second day, prosecutor Mr. Fenneman called Mr. Travis, a ballistics expert, to testify. Mr. Travis provided detailed information about the gunshot wound, its trajectory, and the circumstances surrounding it. He concluded that the shooting was not an accident, as suggested by the defense. The defense struggles to counter Mr. Travis's expert analysis, leaving the possibility of an accident seemingly unlikely. On the fifth day, the defense calls Angela to the stand. She described her troubled marriage and the fears she felt towards her husband, Charlie. Angela initially insists that the shooting was an accident during a struggle over the gun, but she later appears to contradict herself, suggesting she might have lost control and intentionally shot Charlie. Under cross-examination by Mr. Fenneman, Angela's defense crumbles as she struggles to explain the circumstances of the shooting. Her inconsistent statements weaken her credibility, and Mr. Fenneman challenges her account, suggesting that her husband had intended to reconcile with her before the incident. In a surprising turn, Angela confesses that Charlie deserved to die because of his criminal activities and the danger he posed to others. However, she insists that the shooting was still an accident. Joseph carefully outlined the steps the jury must follow to determine the verdict. First, they must ascertain if the shooting was accidental, and if not, whether Angela intended to kill or seriously injure her husband. Additionally, the judge considers whether to include the defense of loss of control for the jury to consider. The defense argues that Angela was a battered wife who may have acted out of fear, while the prosecution maintains she deliberately shot her husband. The jury reaches a surprisingly quick verdict, finding Angela not guilty of both murder and manslaughter. Joseph reflected on the jury's decision, questioning whether the jury's verdict is based on a belief that Charlie Bridges deserved to die, rather than on legal grounds. She grappled with the implications of such a verdict and its potential impact on the rule of law. In the end, she notes the historical context of juries, occasionally delivering perverse verdicts that challenge legal norms, and concludes that the power of jurors to return a verdict they believe to be right remains a fundamental aspect of the legal system. The author finally addresses the persistent issue of crime in society. She emphasizes that while individuals bear responsibility for their actions, society must also recognize its role in shaping these individuals. She questions the effectiveness of traditional approaches to crime prevention, such as punishment and rehabilitation, suggesting that these measures often come too late in the process, and she argues for a more proactive approach focused on equipping individuals, especially children, with the tools to make better choices and feel a sense of belonging within society. The ultimate goal is to reduce crime by addressing its root causes and offering more opportunities for positive paths in life. Our final book is from Preet Bharara, who was the former U.S. Attorney for the Southern District of New York. As a supervisor of over 200 assistant U.S. attorneys, he oversaw cases ranging from cybercrime to gang violence. He's been featured as among Time magazine's 100 most influential people in the world, and included on Vanity Fair's new establishment list. Doing Justice shares the wisdom that Bharara gained over the years, from tips that every trial lawyer should know, to his thoughts on prison reform. Here he is speaking to the NYU School of Law Brennan Center for Justice.
So another chapter in the book deals directly with criticism that you have to face if you do anything, I think, that's significant. And certainly if you're a prosecutor, you can face criticism. And I've faced, in my office, has faced criticism of being too tough and not tough enough, depending on your perspective, depending on the case, and sometimes in the same case. People thought we didn't go far enough or we went too far. And there have been allegations about, motivations about why you do things. I was banned from Russia because of a case we brought against Victor Bout. I detail, a set of circumstances in which, in a very serious way, in the country of my birth, accusations that I am, purposely targeted people of South Asian descent, Indians in this country and elsewhere, for prosecution because I was somehow self-loathing and wanted to prove something, according to one article, to my white masters, presumably Eric Holder and Barack Obama. Criticism is a part of the job and part of the lay of the land. Donald Trump didn't make up witch hunt. I actually had an assistant compile all the times that significant targets had said witch hunt, and it would have elongated the book by double. So the fact that people have a criticism, I think, is okay, and you have to have a good and honest debate. What I worry about with respect to criticism is if it spawns, I think, suggestions not based on evidence, like some of these accusations from the country of my birth, that a particular action was taken or intended for racist reasons or for personal gain. I mean, there have been all sorts of accusations about how we handled the financial crisis or didn't handle accountability in the financial crisis. And so the first thing I'll say is, the people that I know, the professionals, either the NYPD or the FBI or the DEA or in my own office, in every case that I'm aware of, and they made mistakes. And by the way, I'm very honest in the book about things that, maybe we didn't do perfectly, maybe things that I overstated and I shouldn't have. I got rebuked by a judge. I talk about that. I don't shy away from it. But in my experience, whether you believe it, but people believe it or not, on the Bronx 120 case or anything else, the intentions were good. And people were acting in good faith. And like in a lot of places in New York, the overall crime rate, as that CUNY report suggests, and the related Intercept article suggests, the overall crime rate in the country has gone down. And so that's causing, I think correctly, a good and honest rethinking about how we go about dealing with crime and how we go about dealing with punishment. But there are still places where crime is a huge problem. One of the first things I did when I was U.S. Attorney was go to Newburgh, New York, that had a significant gang problem. In fact, the homicide rate in Newburgh, New York, a little bit north of the city, was 4 times what it was anywhere else in New York. And I met with the community. It was the first community meetings I had. And I met with moms, and all African-American moms, who said, you have to do something here. And the first mom I remember meeting in a setting at a community center said, I lost a son to gang violence. And she's telling the story, and people, grown men and women are crying in the room. And then the next mom speaks, and I'm thinking, what could be worse than what the first mom said? And the second mom says, I lost 2 sons. So, the people in that room in Newburgh, New York, committed themselves to taking serious action. And we brought big gang cases, and we did big takedowns of Crips and Bloods in Newburgh because the community was crying out for it, and because we cared about the victims in the community who were also people of color. Yeah, the people who were charged were people of color and members of gangs and associates of members in gangs and other enablers of them. But the interest was in helping the community and making it safer. So I appreciate the criticism that, some of the rhetoric that surrounded that criminal action made it seem like every single person was a member of a gang, and there was a taint on the part of folks who are maybe not as criminally liable as the people at the top.
Finding the truth is rarely as simple as expressions like connect the dots or follow the money suggest. When it comes to criminal law, the pursuit of justice is about discovering the truth and holding someone accountable for a crime. For a criminal case, this process starts with the inquiry phase. During this phase, an investigator must be committed to the truth. This may seem obvious, but a lazy investigator can set a low bar for satisfactory evidence and jump at the first chance to close a case. However, even a committed investigator can fall short as a result of their biases or presumptions about guilt and innocence. In 1989, Bharara received a call from Jessica, a friend who was shocked to learn that 2 people she knew, a married couple by the name of Jose and Kitty Menendez, had been brutally murdered in their living room. When the police eventually arrested Jose and Kitty's children, Lyle and Eric, for the crime, Jessica couldn't believe it. She wondered how the police could get things so wrong. Despite Jessica's firm belief that the sons couldn't have murdered their parents, they had. In 1996, the brothers were finally convicted after confessing to the crime. This was the first time the author understood that one can never be completely sure of what someone else is capable of and should always withhold one's presumptions of guilt and innocence. Another hallmark of a committed investigator is their work ethic. One of the most esteemed investigators in this regard is Kenny McCabe. Before he passed away in 2006, McCabe was a living legend for working on cases involving the 5 mafia families: Gambino, Bonanno, Genovese, Lucchese, and Colombo. Yes, McCabe was a real-life mob buster, and he was famous for his meticulous and detailed work. Not only did he have files and photos on just about everyone, but he could also tell you how high or low a mobster's ranking was just by observing their behaviour. McCabe never cut corners. He put in the work of collecting one piece of evidence at a time and building a case. In fact, he was so good at his job that even the mobsters had respect for him. If they got busted by McCabe, they knew they'd been caught fair and square. Mistakes can happen to anyone, including experts, but awareness of human biases and a commitment to the truth can reduce errors during investigations. A case example is the 2004 Madrid train bombings, where a fingerprint initially led investigators to Brandon Mayfield, an American lawyer. Despite unusual connections to Islam, surveillance yielded no conclusive evidence. 3 experts confirmed the fingerprint match, but a 4th disagreed, and the Spanish police identified a different suspect. Ultimately, Mayfield was cleared of charges, highlighting the fallibility of strong evidence. The case serves as a cautionary tale against overconfidence in initial analysis and emphasizes the importance of re-evaluating evidence. Bharara also believes effective investigation often hinges on asking the right questions and challenging established procedures. For example, in insider trading cases, the question, "Why aren't we using wiretaps?" transformed investigations, recognizing their significance in tracking non-public information exchange. Gaining a cooperative witness can be challenging due to the risk of being labelled a snitch, yet it raises ethical questions about reduced sentences for serious crimes. An empathetic and well-informed approach to questioning witnesses, as demonstrated by investigator Steve Braccini, can be more effective than aggression. Understanding a witness's background and building rapport, as Braccini did, can lead to valuable cooperation even in challenging situations. In criminal investigations, once evidence suggests a charge may be necessary, it's crucial to carefully deliberate and consider alternative explanations or doubts before accusing someone. Accusations have a profound impact on individuals' lives, and they cannot be undone. Therefore, prosecutors must approach the decision-making process without preconceived outcomes, despite potential pressure for results. Over-eager law enforcement officials can threaten injustice, making diligence and thoughtful consideration paramount. A notable example involves cases against powerful politicians in New York, where the author emphasized that the focus was on doing the right thing and upholding the law rather than securing convictions. Pressure on prosecutors can come not only from high-profile cases, but also from concerns about public safety. A unique and disturbing case involved Gilberto Val, a police officer with a dark online presence. His wife discovered his involvement in a website discussing gruesome acts involving real women, including herself, leading her to contact the police. Val's online activities raised questions about distinguishing fantasy from real threats, especially since he had stalked a woman he knew. The author charged Val with conspiracy to kidnap due to potential danger, even without concrete evidence. Although Val was initially convicted, the verdict was later overturned, as his plans appeared to be more fantasy than reality. However, subsequent arrests of co-conspirators engaging in similar activities resulted in convictions. Justice often requires discretion in law enforcement and prosecution. While the government could choose to prosecute every violation to the fullest extent, this approach doesn't leave room for considerations of fairness and justice. One example is the controversial policy of prosecuting every trespassing immigrant at the southern border, leading to the separation of children from their parents. Prosecutors should exercise ethical responsibility and be mindful of fairness. knowing when not to prosecute is as important as deciding when to pursue charges. Cases like a prison escapee who broke out for a brief rendezvous and returned willingly may warrant discretion. Conversely, a change in cultural attitudes can lead to the prosecution of previously unpunished crimes, as seen with the Me Too movement's impact on cases involving sexual assault allegations against powerful individuals like Harvey Weinstein. After the inquiry and accusation phases, the next step is judgment, where the case is prepared and presented in court. It's crucial to uphold a commitment to truth and justice, even if it doesn't align with its chances of winning. In the case of Sue Ann, a sex worker who was robbed, assaulted, and identified one of her attackers as her roommate's ex-boyfriend Bam, the local DA declined to take the case due to Sue Ann's history of mental illness and drug abuse. However, prosecutors Tatiana Martins and Can Noaday found crucial evidence, including marked bills, and took the case to court. Despite efforts to discredit Sue Ann's character, the jury believed her, leading to a guilty verdict and justice being served. Prosecutors aim to avoid surprises in court, studying the assigned judge's personality, ensuring thorough preparation. In the case of Judge T.S. Ellis III, presiding over Paul Manafort's 2018 trial, Ellis's lack of patience and reprimand to prosecutors for a witness's presence in the courtroom tilted the scales of justice, requiring prosecutors to file a motion for clarification. Similarly, in the case of Dean Skelos, accused of favouring businesses hiring his son, prosecutors conducted a mock trial to anticipate the jury's response to the defence's strategy. Ultimately, Skelos received 51 months in jail, and his son Adam got 48 months. After a guilty verdict, sentencing is determined by the judge, who must balance punishment with fairness. The case of Carlina Rainier White, kidnapped as a baby and raised by her abductor Anne Petway, exemplifies this challenge. Petway faced a minimum 20-year sentence for child kidnapping. Her lawyer offered to plead guilty to some charges, leaving the sentence to the judge's discretion, or proceed to trial. Considering Petway's miscarriages, the judge sentenced her to 12 years, deeming it a crime of selfishness. While Carlina's parents weren't satisfied, the author remains uncertain if justice was truly served in this complex case. The prison system is a critical aspect of the justice system, even if prosecutors aren't experts on it. It raises concerns about how prisoners are treated in a just society, as dehumanizing conditions can lead to cruelty among both inmates and guards. Rikers Island Penitentiary, overseen by the author in the Southern District of New York, exemplifies these issues, with more mentally ill individuals than all state psychiatric hospitals combined. A case involving Jason Echevarria, who died from ingesting toxic chemicals while ignored by a guard, highlights the system's problems. Despite reform efforts, some argue for Rikers' complete reconstruction due to its persistent culture of violence. And the aftermath of the September 11th attacks saw a rise in hate crimes against individuals from the Middle East and the US. Mark Anthony Stroman, a white supremacist, carried out a series of shootings, killing Waqar Hassan and Vasudev Patel, who received the death penalty but survived by Reis Puyan, an immigrant from Bangladesh who forgave Stroman and campaigned for his release. Stroman expressed gratitude for Puyan's compassion before his execution in 2011, recognizing the need to end hatred. This story underscores the power of forgiveness and human qualities beyond the law in promoting societal improvement. So to sum up, Joseph says in Unlawful Killings that crime is a choice made by individuals, but she argues that the current approach of punishing, deterring, or rehabilitating criminals is not effectively reducing crime rates. Instead, the author suggests a different approach, focusing on preventing individuals from choosing a life of crime in the first place. The author highlights the importance of equipping individuals, particularly young people, with the tools to make better choices by addressing underlying issues such as poverty, abuse, and mental health. Joseph proposes that society should ensure that every child has the opportunity to make positive choices and feel included in the social fabric. Ultimately, she advocates for a shift in perspective from reacting to crimes after they occur to proactively preventing individuals from becoming offenders. By doing so, society can create a better future with fewer victims, reduced financial costs, and increased overall happiness. Bharara says in Doing Justice that the legitimacy of the US criminal justice system relies on those who uphold it. Investigators should prioritize truth over case closure, and prosecutors should balance public safety with seeking justice for victims. It's not just about winning in court. We must consider the dehumanizing impact of the prison system. In a humane society, accountability for the powerful and protection for the powerless are paramount. I've seen the legal system firsthand, unfortunately. It is absolutely atrocious for vulnerable people to navigate. So many people fall through the cracks of society, and the legal system only sees the end result. What do you think? Do you think the legal system needs changing? Let us know. Please join in on the conversation by following @HowToBe247 on Instagram, Twitter, and Facebook, and subscribe on the podcast, which can be found via www.howtobe247.com. We have Spotify polls, so feel free to send your responses there too. You can even check out all our exclusive unseen bonus material from every single interview, all for a price of a coffee on both Spotify and Patreon under the name Behind the Scenes, Exclusives from the How to Be Books podcast. All the latest ones are on Spotify, while more than 30 exclusives are on Patreon. We've also launched a shop on Patreon where you can buy one-off exclusives. Sign up to be part of the movement. Please do leave a review if you found this helpful and you want to be featured. Remember to check out the website as well. We had the opportunity to review Matthew Perry's memoir following his tragic death. Not to mention, we got to go to some great events, including the Black to the Future Festival and the Festival of the Accused, about the historic injustice against women accused of witchcraft. We had some incredible interviews with guests such as the renowned author of The Artist's Way, Julia Cameron, on her book for National Authors' Day, and how it fares in an age of AI, as well as top linguistic professor Dr. Naomi S. Barron, who chatted to us about what AI is doing to language. Before we go, please check out Zencastr. We do all our interviews with it, and it's for free. If you've ever thought about podcasting before and realised that you need a lot of different tools and services, those days are over. With Zencastr's all-in-one podcasting platform, you can create your podcast all in one place and distribute to Spotify, Apple, and other major destinations. Go to zencastr.com/pricing and use my code HowToBeBooks, and you'll get 30% off your first month of any Zencastr paid plan. I want you to have the same easy experiences I do for all my podcasting and content needs. It's time to share your story. See you in 2 weeks' time.